is less. Yes.
Good afternoon. Good afternoon, participants. We are now starting with the Module 3, Technical Session 5 of our Interdisciplinary Faculty Development Program. This particular technical session, titled Evolution of Juvenile Justice System, Institutionalization and Alternatives, is very aptly would be conducted by Professor Dr. Kavita Singh, a professor in West Bengal National University of Juridical Sciences, Kolkata. Ma'am, herself being a teacher, professor, and having a variety and having a diverse experience in numerous years, has a complete expertise in this particular field of juvenile justice system. The administration of criminal justice is having a is having or is particularly concentrating on the factor of the juvenile justice and how the juveniles are being treated in the criminal law when they are as the accused or even as the victims. Having a diverse experience with the criminal laws and the research publications in the various criminal law journals, ma'am would be successfully entailing this entire session, holding various positions in NUJS, including the member of the Academic Council, the Quality Control Cell, and even the member of the All India Law Teachers Congress, the member of the Postgraduate Council, member of a Staff Welfare Committee, and member of the Legal Aid Society. She is also honoring the executive member of the Indian Society of Victimology. She is the coordinator of the School of Criminal Justice and Administration and the former faculty advisor for the Society for the Advancement of Criminal Justice and Administration, also the former and the editor-in-chief of the online NUJS Criminal Law Journal. So, having a diverse experience in this particular field of the administration of criminal justice, I welcome you, ma'am, in this interdisciplinary FDP program and would request you to kindly conduct this session.
Thank you, Professor Seema. I am humbled. So elaborate introduction you gave me. Anyway, I would like to thank the organizing team and in particular Professor Seema for inviting me and giving me this opportunity to present before you and the faculty development program on emerging trends in administration of criminal justice and forensic science is actually the need of the hour. And you all are knowing that we are in a transition period where we are going to have a new completely a new code of criminal law in place. Maybe in a few months we are waiting for the same. And the issue of juvenile in conflict with law is again a very crucial area of discussion in today's time in the criminal justice administration. So what I have done is I have a small PPT to share with you all, and I will present the PPT. In the discussion, I have divided my discussion into three parts. In the first part, in the three parts, first we will be discussing the basic introduction of the area in which we are discussing, and then I cannot see the slides. It should be Google doc slides. Google Slides. Acha. 1 minute. So I have to actually convert it into when I send it into open it in a Google slide form. No? 1 minute. So give me a few minutes. I'll just do it. I did
Sure,
not
ma'am.
know. I did not know. Otherwise, I would have shared it to you only. Let me first open and see. Pardon me for taking so much of time. Actually, first time
No,
I'm
true.
doing Stream Yard.
Yes, ma'am.
Uh-huh. 1 minute.
Uh,
Now I will share.
hmm.
Can you see?
No, ma'am, we are unable to see. Ma'am,
I
on
think it is coming. Just see. There was an issue with your file. Please try again in a title little while. Okay. Can I share it with you?
yes, ma'am. Please.
Then it will do, no?
Yes, ma'am. You give it to us. We would be sharing the file.
Then that will be easy, I think so, because I'm not able to. I have shared it. Just check. No? I have already shared. Check.
Okay, ma'am.
So I was talking about that, I have divided my discussion into three parts. In the first part, the introductory juvenile jurisprudence. In the second part, the evolution and the principles and objectives. And in the third part, I'm talking about the core 2015 juvenile justice law in place. So to start with, when we talk about this juvenile jurisprudence, we are actually basically looking into,
Ma'am,
the
ma'am, where have you sent it? Sorry to disturb you.
HOD law,
Okay.
the head law. This is all your na
Ma'am,
AC.
can you send it on the WhatsApp if it is possible?
I can send it in the WhatsApp also.
Yeah.
Wait. Nowadays, it is very easy to send documents.
Yes, ma'am. The AI and all the technology has made it all these things very easy.
Easy, huh? So. Did you get it in WhatsApp?
Not up till now, ma'am. Yes, ma'am, I have.
Hmm. So I was talking about the juvenile jurisprudence. Juveniles are considered to be the future generation of the country, and therefore they need to be protected, and they need to be prevented from further harm, and they have to be given a holistic environment to grow so that they become a disciplined future generation of the country and a workforce for the country. So, keeping in mind that the role of the criminal justice administration is very important. Can you see the? Can you did you can present? Is it possible?
Yes, ma'am, we are just processing. It is just getting processed. We are just adding the screen.
Ha ha ha. So, therefore, what happens that juvenile, we need to protect them from becoming having a delinquent behavior, or they become child in need of care and protection. So, therefore, that was the objective of having the juvenile justice system in place. And initially, if we look into that, this was not the situation. The criminals were the children were treated at par with the other criminals, and they were given they were given same treatment as it was given to the so taking from there, you if you see that the requirement of treating the children differently was the evolution or the change in the system. And when India got independent and post
Ma'am,
independent
ma'am, now you can see your PPT.
slide. I can see my
Yes, the
PPT.
slides are viewable. Fine.
Go to the
Uh,
second slide.
yes, sure.
So I was talking about here that the initially they were the children in conflict with law were treated at par with adults, and the punishments and procedure was same for both. There was no difference. But when the evolution of the juvenile jurisprudence took place later on post independence era, we will see that how the differential treatment for children was felt the need of the hour, and because of that, India being a welfare state, in its governments, in the governance model, it required that state play a very significant role in preservation and promotion of their citizens, economically and socially. Their well-being. So the children being part of the citizen of the country, the idea of equality of opportunity and equitable distribution of wealth to support the citizens were the basic. So here, welfare of the juveniles, the children being the future, future of the country, the welfare state owed a huge responsibility towards the children. Then the next the doctrine which we need to talk about is the parents patia. The All of you know the theory that it is an obligation of the state to protect and to take into custody the rights and privileges of the citizens for discharging their obligations. So here also, what we find is that the responsibility towards children in a parent patriarch theory was that state is the caretaker and the protector of the rights of the children as well, while they are discharging their duties and obligation towards the children. Uh, then we come down to the mens rea and the children's right again. So in mens rea, if we see in the 1860 IPC law, what we found that we had two sections in the general exception chapter which talked about the guilty mind of the children, and these two sections in particular, 82 and 83, one being Dolly in Capax and the other one Dolly Capax, had the idea that the children below the age of 7 years do not have mens rea to commit crime, and children above 7 years and below 12 years had qualified immunity, that if they ever are able to understand the nature and consequences of their act, and their after committing the crime, their actions were taken into consideration to see that the child understood the nature of the act which he has committed is right or wrong, and therefore determining the guilt of the child was there. But post independence, what we find that the laws were drafted in such a way to give juvenile a different treatment altogether in the system, and therefore guilty intentions of the children who had not completed 18 years of age was the approach of the welfare state, and thereby protecting the rights of the children in the system. Next slide, please. So this is the historical development which you can see. In 1850, we had the Apprentice Act. In 1864, we had the Whipping Act. 1898, Reformatory Schools Act. 1920, Children Act. 1960, we had Model Children Act with no imprisonment for children. In 1986, so we had the first Juvenile Justice Act, uniformly applicable in India throughout all the states. And here, boys under the age of 16 years and girls under the age of 18 years were considered, no punishment for them, and they were not considered as accused of crime or child in conflict with law in particular. Then came the 2000 law. So 2000 law was drafted at par with the requirement of the CRC, Child Rights Convention, and they did not discriminate it with this law. 2000 law did not discriminate between boys and girls, and all children were equal, be it boy or be it girl, and anyone under who has not completed 18 years of age were taken into consideration. And here you will see that we have got the two types of children. One is the child in need, in conflict with law, and the other one child in need of care and protection. And so children were considered those children who were abandoned children, those children who were whose parents were not known, those children who were in orphanage, children in streets. They all were considered as children in need of care and protection, and state owed a responsibility towards those children. Their well-being and their rights need to be protected was ensured under the 2000 law. After the Nirbhaya incident, we actually one of the accused in the Nirbhaya case was released after 3 years, and according to the 2000 law, the highest possible punishment could not be given under that 2000 law. So a need was felt countrywide that we have a separate section of for the children who are above 16 years of age and who has not completed 18 years of age, and if they commit serious heinous crime, then they would be treated at par with adult. This change was introduced in 2015. So all children under 18, but selective transfer of malice in case of children above 16 years of age and has not completed 18 years of age to be tried in an adult court for heinous offense. Next slide, please. So the objective of the 2015 law was to cater to the basic needs through proper care, protection, development, treatment, and social reintegration of these children into the society, be it children in conflict with law or be it children in need of care and protection. The in this law also had a huge chapter on adoption law. So initially only one section was there in the 2000 law dealing with the provisions of adoption as a secular law, Juvenile Justice Care and Protection Act for adoption as a secular law, and the juvenile justice rules had the detailing of the adoption procedures. But in 2015, when the law was changed, the entire procedure and detailings of the adoption under juvenile justice care and protection was done, and a huge chapter were created with putting in the kara guidelines relating to adoption within the statute itself. Then it also talks of the new law also talks about the disposal of matter in the best interest of the child. So the doctrine of best interest of the child should have been given priority, and welfare of the child would be the priority of the system, be it criminal justice system or be it the welfare state system. And for the rehabilitation of these children through the process provided and the institutions and bodies established under the law to take care of these children. So if child is in need of care and protection, then in that case, we have huge institutional bodies who take care of this. Caregivers are there in this system, and then these children in need of care and protection could be actually given in adoption to parents who are who have the who are in need of a child through the process of adoption. And those children who are there in the system who are not given in adoption, state would take the responsibility of their well-being, welfare, educational development, and holistic development of these children, so that these children can, on becoming adults, can be mainstreamed into the society by having proper educational facility, vocational trainings, and so that they can earn their living once they become adult. So the process of institution was inbuilt there in the new law. Apart from that, for the children in need of care and protection, up till the age of 21, they were kept in juvenile institutions, and beyond 21 years, if they are incarcerated, then in the correctional home, and completing the period of incarceration. And during this period, they would again be given therapeutic treatment, and they would be then released. At the time when they would be released, then the triple R concept of reformation, rehabilitation, and reintegration of these children into the society would be possible for the kind of treatment they are given in the institutional arrangement. Next slide. We will discuss this again. We will revisit this. Section 3 of the 2015 law talks about general fundamental principles, and these general fundamental principles are actually brought forth from the Child Rights Convention and incorporated here. This chapter is the general principles of care and protection of children, and the central government, the state government, the board, the welfare agencies, and other non-government and non-governmental agencies, as the case may be, are shouldering the responsibility of implementing the provisions of the law, and they are to be guided by these fundamental principles. So go to the next slide, which provides the principle. And the first principle is the principle of presumption of innocence. Now, in acquisitorial system, we have the doctrine of presumption of innocence, and we follow the cardinal principle of criminal law that let hundreds of accused go scot free, not a single innocent person should be convicted. and the court is going to presume that all accused in front of the court are innocent until proven guilty. So the responsibility of the prosecution becomes important, that they have to prove beyond reasonable doubt the guilt of the accused. So this in this case, any child shall be presumed to be innocent of any malefied or criminal intent up to the age of 18 years. So a person who has not completed 18 years. The second principle needs to be taken care of is the dignity and worth. So every child has a right to dignity, and needs the child's dignity has to be protected and given importance. The next principle was principle of participation, and that means, be it in any system, the participation of the child it has to be there in all the welfare schemes which are available to the child. Apart from that, if child is in conflict with law, then in that case, the doctrine of participation in getting an equal opportunity to participate in the criminal justice process, while whereby getting an opportunity to defend himself through the lawyer representing the juvenile was ensured in this principle. Next, please. Coming to this, a very important principle, that is principle of best interest. So this doctrine of best interest is, all the decisions regarding the child shall be based on the primary consideration that they are in the best interest of the child, and to help the child to develop with full potential. So this doctrine of best interest of the child needs to be protected, be it child in need of care and protection, or be it child in conflict with law. Coming to the next principle, the principle of family responsibility. So the basically the family owes the responsibility of the child, and sometimes what happens in the system, that the family is unable to take care of the child due to poverty, due to coming from the socially economically backward class people, or people who are not well enough to actually feed their children, provide well education to their children. And then in that case, the responsibility would shift to the state, and parents can actually surrender their children to the state, and then state would take care of the well-being of the children. But the primary responsibility has to be shouldered by the parents and if family, for the well-being and holistic development of the children. And in doing so, it is followed by the next principle, that is principle of safety. So as the family is responsible for the protection, prevention, and care giving to the child, and similarly the state owes a responsibility that the child need safety, and all measures have to be taken by the state to ensure the safety of the children, and in particularly children who has not completed 18 years of age. Next slide, please. So the state was a responsibility of taking positive steps and measures, and come up with various schemes and policies for the development and of the child, and need of, okay, keeping in mind the need of the children and their holistic development. The next principle talks about non-stigmatizing semantics, and here in the adversarial or acquisitorial system, the words are not to be used in process of pertaining to child. Like now we have according to the requirement of CRC, we are not supposed to designate a child as a delinquent child, and where there we have now we are using more human rights protective words like child in conflict with law. And then the whole system of the criminal justice system should be in a manner where the child is not never ever been stigmatized in the system. So even the investigation has been completed against the child, and the report has to be filed by the police, that generally in layman, in the criminal justice system, we talk about that report to be the charge sheet. But for the children, we don't use the word charge sheet in particular, because it contains some degrading human rights words. So that is why the word used is the final report, that which has been submitted by the police, and the police findings are then there in the report, and the JJB or the children court would take into consideration that report for further trial and determination of the case of a child in conflict with law. The next principle talks about non-waivers right. So no waiver of any rights of child is permissible or valid, whether sought by child or person acting on behalf of the child, or board or committee, or any non-exercise of fundamental rights shall not amount to waiver. So the wavering of rights are not allowed, and whatever rights are to be available to the child needs to be provided to the child. And the system has been made in such a way it should be a child friendly system. And in child friendly system, you will find that the children's rights are protected and taken care of. Next is followed by the equality and non-discrimination principle. So children are equal before the law, and they cannot be discriminated any way. Children coming from any caste, creed, language, creed, etc. Next principle is right to privacy and confidentiality. So even the laws have been drafted in such a way that the child would be given a fictitious name when the child is in conflict with law, so that the right to privacy of the child, anonymity of the child, and confidentiality of the child would be maintained. So every child shall have a right to protection of his privacy and confidentiality by all means throughout the judicial process. Even in the orders passed by the court, maybe be it children court or JJB, they are to follow this principle and have to incorporate the principle of privacy and confidentiality. Then followed by principle of institutionalization as a measure of last resort. This which we will be focusing in our discussion. A child shall be placed in institutional care as a step of last resort for making a reasonable inquiry. So at all cost, if parents are known and parents are available, then the child would be handed over to the parents for future care and participation in the inquiry and trial. But if the parents are not found or not known to, or where there is the court finds it doubtful that the parents are not the genuine parents, then as a last measure would send the child to an institutional care for inquiry and investigation and trial. Next is the principle of repatriation and restoration. This principle is very important in the case that the children has to be restored back into the position prior to the situation where the child was trapped into the situation of committing crime. And right to privacy. Sorry, in repatriation and restoration, it is the responsibility of the criminal justice system to restore the child back into the society, and in this process the enforcement agencies have to see that that their rights are not violated. Next slide, please. uh, Next principle is fresh start. So so for petty offenses and for say serious offenses also, a minimum opportunity has to be given to juvenile, so that the juvenile can be released on admonition and probation, so that the alternate method of incarceration can be taken care of, and given an opportunity to start afresh. and the triple R concept, which we talk about: reformation, rehabilitation, and reintegration of these juveniles into the mainstream of the society, has to be taken care of by principle of fresh start. And principle of diversion should also be there. A principle of natural justice has to be followed. So if natural justice is not followed, then the trial cannot be considered as a fair trial. So the and in case of principle of natural justice, if the juvenile comes from a socially economically backward class, then unable to have a lawyer of its own, and legal aid lawyer will be provided by the court to the juvenile. So basic procedure of standard of fairness shall be adhered to, including the right to fair hearing, rule against bias, right to be reviewed by all personnel or bodies acting in judicial capacity under this particular act. Next, please. Next slide. So we come down to the next part of our discussion, that second part, the scheme of juvenile justice 2015 act particularly deals with the children who has not completed 18 years of age, and uh, they are children who in conflict with law, or child in need of care and protection. So we have two schemes: one for the child in conflict with law, and one for the child in need of care and protection. So in the new law, as I have already told you, that we have two again further classification of two schemes: uh, uh, the juvenile justice board and the children court are the two schemes. And so according to order under section 18, if the child is below 18 years of age and committed any offense, and if it is between 16 years of age and 18 years of age, has committed petty offense or serious offense, then in that case treatment will be different, and the case will be taken care of by the juvenile justice board. When the juvenile is above 16 years of age, who has not completed 18 years of age, has committed heinous offense, then the JJB will do the preliminary assessment with the help of experts. And when the JJB comes to the conclusion that he has the culpability, the child has the culpability to commit the crime, uh, in those cases, in a selective manner, will transfer the case to the children court. So review and assessment and disposal then will be conducted of that case by the children court. And when we talk about child in need of care and protection, we have child welfare committee, and in child welfare committee is going to decide or take steps relating to restoration of the child, sending the child to home, or children's home, or other residential homes, or foster care, or then proceed for adoption. So this two schemes are available in the Juvenile Justice Act of 2015. Next slide, please. Next slide. Now, when the JJB is doing the determination of the culpability of the juvenile, in that case, when the juvenile is above 16 years of age and less than 18 years of age, has alleged to have committed heinous offense, the steps to be taken by the JJB is to determine the age, find if the offense is heinous, findings if the offenses is heinous, preliminary assessment, transfer the transfer the case to the children court or not to decide upon it. And if orders have of transfer is not if the case is not transferred, then what will be the position? Next, please. Next slide. So age determination. Now anyone above the age of 16 years, but who has not completed 18 years of age as on date of the offense, when the offense is committed, we have a Supreme Court judgment, Rajendra Chandler of the state of Chhattisgarh. Here in 2002, Supreme Court actually laid down that if the if the child claims that child is juvenile, and child then in that case is not able to prove that there is no proper documentary evidence, or any evidence to be produced before the court. At that point of time, benefit of doubt will go in favor of the child up to 1 year on the lower side. And for this, the standard of proof is not beyond reasonable doubt, but only preponderance of probability. So balance of probability doctrine we are going to apply, and not standard of proof of beyond reasonable doubt proving the document. Next slide. I'll come to this once again when I'm doing the detailing in the third part of it.
Okay, ma'am.
So presumption and determination of age. In case of a committee or board has reasonable ground for doubt whether the person brought before the board or the committee, the board shall undertake age determination process by seeking evidence by obtaining date of birth of certificate of from the school, birth certificate given by the corporation or municipal authority or panchayat. Only in absence of 1 and 2, they shall be determined by ossification test. And you all know that ossification test is a test which is plus minus 2 years. So according to the ossification test, if it says that the child is 14 years of age, then if you it can be 16 also, and 12 also. So the ossification test is not a authentic test. But now currently under the forensic science regime, advancement of forensic science regime, what we find that new medical tests have come up, which gives advanced calculation of the test of the age of the child. But that again, the court is going to presume, and I told you benefit of doubt can go to the child. Next slide, please. Now, classification offences as heinous under section 33, 45 and 54. 54 is 2019 amendment. So, heinous offence includes the offence for which the minimum punishment under the Indian Penal Code or other law for time being in force is 7 years or more. And petty offences are those offences which includes maximum punishment under Indian Penal Code or any other law for time being in force is imprisonment up to 3 years. And serious offences include offences which are punishment for Indian Penal Code or other laws for the time being is imprisonment between 3 years to 7 years of imprisonment. Next, please. So heinous crime is 7 years and above. Whatever imprisonment 7 years and above will be brought into the category of heinous offense. Next, please. So to classify offense, jurisdiction and order, if we like to take into this problem, two 17-year-old boy are produced before the court for robbery. One of them has pushed a woman. She fell down and they snatched a note of 500 rupees from her hand and ran away. So in this case, will this offense be a petty offense or a heinous offense or a serious offense? Because this is a case of robbery, extortion, criminal force. What offense? Will it be heinous offense, petty offense, or serious offense? No idea. Next, please. Robbery is a serious offense, heinous offense. So under section 18, orders which the court may pass, advise or admonition. We all know, just giving threat and advise, and release him on admonition, scoldings. So second is group counseling and similar activities. Third one is community service. Fourth is fine. Release under parent, guardian, or fit person for 3 years monitoring. The release under fit person, maximum 3 years can be given, and sent to special home. Special home meant for child in conflict with law. Maximum period is 23 years for providing reformative services, including education, skill development, counseling, behavioral modification, therapy, psychiatric support during the period of stay in the special home. So I told you therapeutic treatment and giving them opportunity to learn so that they learn skills which when on release they can be rehabilitated and reintegrated into the society. So there is a proviso that if the conduct and behavior of child has been such that it would not be the in the child's interest or interest of other children housed in the special home, the board may send such children to a place of safety. So that provision is also there under the law, where these children cannot be kept along with the other children their security is at threat or their development is at stake. Then in that case these childs can be placed in a place of safety by the order of the court. Next please. Next slide. Additional orders which can be passed under section 18 subsection 2 is that if the order is passed under A to G of subsection 1, board may in addition pass order that the child can attend school, attend to vocational training centers, attend to therapeutic centers, prohibit the child from visiting frequently and appearing in specified places. That means restraint order can also be passed. And if the child is a drug abuser or substance abuser, then in that case child can be sent to de-addiction centers and de-addiction program centers as well, rehab centers as well. Next please. So, standard misunderstanding regarding the response to crime is there, punishment and permissive. So, what happens for any kind of crime, the society wants stringent punishment. But if we give stringent punishment to children, that will not serve the objective of reformation, rehabilitation, and reintegration of the society. So there is a constant tension between the punishment and the permissiveness, and that leads to a situation where the children are in a pathetic situation when they are in the criminal justice system. Next please. So, social discipline window. Here in this slide, you will see that when control is high, what we find is that the the tension is more. When control is high, the tension is more, and the children may revolt in such situation and indulge in anti social behavior. So what is the when the control is low, what we find that and support is high. When control is low and support is high, then in that case we see a different picture altogether. So there is a continuous tension in this regard. And in the social discipline window we find four objectives. One is punitive, the other one is restorative, the third one is neglectful, and the fourth one is permissive. So sometimes we oversee, overhear, overheard, and sometimes we give them an opportunity, sometimes we punish them, sometimes we want to restore them back to the society, and sometimes we are neglectful. So in the social discipline window, what we find, there is a continuous tension there. And so the criminal justice administration, when dealing with children, needs to balance this. Otherwise, then in that case, the real objective for which the law was brought in will not be achieved. Next, please. Next slide. So here you see to with not for has been added to balance the situation. There is a very little change in the slide, whereby we have added to punitive with restorative, not neglectful, and for permissive. And when we take this approach, then in that case we will be dealing the children differently, and give the child an opportunity, though the child had been indulged in criminal activity, um, will give an opportunity to be actually reformed and rehabilitated and reintegrated into the society. Next, please. Next slide. So I was talking about restorative justice approach through community servicing and group counseling. Counseling helps a lot. Be it a normal child or a child in conflict with law, the counseling, continuous counseling helps in holistic growth of the child. So when it comes to a child in conflict with law or child in need of care and protection, there is a propensity that there is a continuous requirement of counseling of these children for the well-being of their mental health. So in the restorative justice approach, the through the community servicing and group counseling is need of the hour. And let's see how we can do it. Next slide, please. What needs to be done to deal with it? Next slide. Quickly we can have. So orders which the board can pass, if the child is above 16 years and has committed an heinous crime and who is not completed 18 years, when the child is culpability is required to be determined, then then in that case, when a proper approach has to be there to determine the culpability, and then pass the responsibility to the children court by transferring the case to the children court. And when the court finds that the child is the maturity level is not that much to understand the act which he has committed, and he is not culpable in the sense, I'm not saying that he has not committed the crime, but he does not have the mental ability matured enough to commit the crime, then not to transfer the case to the children court, do a conduct inquiry in the offense, and pass an order which is suitable for the child. So we will look into under next please. Next slide. So the order which has to be passed under by the court, in when the court does not send, the JJB does not send it to the children court, is under section 21. Order which that cannot be passed by the court, that is death penalty or life imprisonment without possibility of release. Now I give you those examples where there is those cases where section inbuilt provides that punishment of life imprisonment, and life imprisonment would mean whole natural life of the person, that is whole natural life of the person means till the death he would be there in the correctional home. So there is no possibility of being released after a certain period of time. So those type of sentence cannot be passed against those juvenile in conflict with law. So child in conflict with law. So sections like 376 subsection 3, 376A, A, B, D, A, D, B, E. These sections you will find that the possibility of release of the accused are barred by such kind of sentence. Next, please. Next slide. Next slide, please. So now we'll come to the third part of our discussion. And in the third part, we will discuss the key features of the JJB. Some I have already discussed and some we will repeat. So, child in conflict with law, I have already discussed under section 233, section 2, subsection 33, 2, subsection 54, and 2, section क्या कहते हैं, where we have discussed the petty offense, the heinous offense, and the serious offense. Like next slide, please. With this, we have already discussed, and under section 21, orders which cannot be passed. Next slide. Can you change the slide, please? So, in case of heinous crime, as we were discussing, which has been alleged committed by the age group of 16 and 18, will be examined by the JJ board to assess the crime has been committed as a child or as an adult. That how that is to determine the maturity level of the child. So, since their assessment will take place by a board, which will have a psychologist, a social expert, it will ensure that the right of the juvenile are duly protected. And if has committed the crime as a child, then the trial of the juvenile will be accordingly placed as a child or an adult in the basis of the assessment. So section 18 subsection 3 talks about it. So under section 18 subsection 3, after preliminary assessment, board may order transfer of the child who is between 16 to 18 years and has committed heinous offense as an adult. Then the board may order transfer of trial to the children court having jurisdiction to try that this particular case. Now, children court is a sessions court notified under the under the law, and so designated courts are there in the district as well as subdivision who is going to deal with these cases. Next slide. Come to next slide, please. Yeah. So offense against children, there are a lot of offenses which are committed against children and can be committed by children and on children. So disclosure of identity of children without reasonable cause will be under section 74. Identity of the child cannot be disclosed. Anonymity of the child have to be maintained. Cruelty inflicted upon child by person having actual custody of the child under section 75. Employment of child for begging under section 76, when whoever gives intoxicant liquor or narcotics, drugs, or psychotropic substance to children, punishable under section 77 or as an offense. Then using child for vending, peddling, carrying, supplying any intoxicant liquor or narcotic drugs, section 78. Exploitation of child by employee, 79. Offering adoption without following provisions of the procedure provided in the chapter, offense under section 80. Selling and or buying children, 81. Corporal punishment by person in charge or employee of institutional care can also be under section 82. Use of child for militant groups or other adults, 83. Kidnapping and abduction, 84. 6 and for this, we are having punishment also, which was there parallelly given in that particular slides. So whoever commits an offense, yes, in the next column, the punishment for all the offenses are also mentioned simultaneously. Come to the next slide. So whoever commits any aforesaid offense on child who is disabled or such person shall be liable for twice the punishment. So twice penalty of such offense will be there. Whoever abets such offense under the act shall be punished with punishment provided for that offense. Particularly, there will be no half or 1/4 or 2/3 like that. So where any act or omission constitutes an offense under the act and also under any other law, such offense shall be liable for punishment which is greater in degree, and any child who commits any offense shall be, 1 minute, क्या लिखा था? Any child who commits an offense under this chapter shall be considered a child in conflict with law. under the act. So I told you about the child in need of care and protection and child in conflict with law. Coming to the next slide. So compulsory registration of institution has to be there. So state government institution or non-governmental institution in the new law has to be registered. It state government or voluntary or non-governmental organization for housing children in need of care and protection or in child in conflict with law shall be registered under this law within a period of 6 months from the date of commencement of this law. So this was given in act in section 41. And what you will find that every there will be renewal of the license registration. So the performance of these homes will be taken care. A review will be done, and then the registration will be renewed. So any person who is in charge of the institution fails to register under the act, there is a offense considered as offense, and is punishment with imprisonment of for 1 year with fine of 1 lakh rupees is there under this law. Then we come down to the next provision, that is leave of absence to a child to be placed in an institution. So this is also possible under section 98 of the law act. In 1998 of the act, you will find that a committee on board may permit leave of absence to a child and allow him on special occasion like examination, marriage of relatives, death of kith or kin, or any emergencies like situation. uh, Leave can be granted for 7 days excluding the time taken for journey. Now, such absence from the institution shall be deemed to be part of the time for which the person was liable to be kept in the home. But when the child in conflict of law has failed to return to the special home on the leave of period being exhausted, then for the time which time he is still liable to be kept in the institution shall be extended, and the board for that period equivalent for the time which lapsed due to such failure. So here the responsibility of the child to stay in that incarceration period will be counted from the date when he returns back or he's brought back. So those number of days he will not be waived off. Like when there is a leave of absence given, then that period will be waived off. So next we come down to the provision of appeals. Now, any aggrieved party by the order of the committee, board, or prefer appeal, or even children courts order prefer appeal. Appeal can be done made within 30 days from the date of order. However, the decision by the committee release on foster care and sponsorship aftercare is appealable to the district magistrate. Appeal shall lie before the Court of Session against the order of the board under section 18. So no appeal shall lie from any order of acquittal made by the board except in heinous offense case. And no appeal shall lie in order to be made by committee in respect of finding that person is not a child in need of care and protection, and no section apply second appeal lies from any order of the Court of Session passed. Court of Session means children court passed on appeal under this particular section. We have another provision for juvenile justice fund. So the provision of creating a juvenile justice fund is there inbuilt in the law, and the concerned state government for the welfare and rehabilitation of the children dealt under this law by means of voluntary donation, contribution, subscription, as the case may be, made by any individual or organization, can collect fund. And under section 106, the state protection society and district protection unit will be created, has been created actually. So state government shall constitute a child protection society for the state, and the child protection unit for every district to take up the matter relating to children with the view to ensure implementation of the act, including implementation of the maintenance of institution under the act and rehabilitation of the children, and to make coordination with various officials and non-governmental organization. And this law specially provides for child welfare police officers and special juvenile police unit. So on this, I have written one paper, child friendly police units. Every police station, there will be one officer who will be designated as juvenile police, and not below the rank of assistant sub inspector, maybe. So he can be designated as a child welfare police officer, and he will exclusively deal with the children, either as a victim of crime or a perpetrator of crime. So this officer is to coordinate all functions of police related to children. State government shall constitute a special juvenile police unit in every district and city, and should include the railway police also dealing with the children. So I have actually written a paper on standard operational procedure for the juvenile special juvenile police unit, do's and don'ts when the juvenile police is dealing with children. So this is an ILI publication available in AIR, because ILI journal has now been published by AIR. So it is available. Sorry, it is available in SSC online as well. So apprehension of child alleged to be in conflict with law. So when the child is apprehended under Section 10 of the new law, which provides as soon as the child in conflict with law is apprehended by juvenile police, such child will be placed before the juvenile board, and the juvenile board by the designated juvenile police welfare police officer, and who shall produce the child within 24 hours, excluding the time of journey. And so no such case, such a child shall be placed before police lockup or lodged in correctional home. So that this is linked with the requirement of having a child friendly corner in every police station. So child in conflict with law will be placed in the child friendly corner for the time being, only for the transit period prior to producing before the board. Now, coming to the provision of bail for the child in need of in conflict with law. So, child in conflict with law, when brought before the board, he may be released on bail or placed under supervision of probationer officer or a fit person, and bail may be denied if release likely to bring him in association with unknown criminals, or release may be exposing him to moral, physical, and psychological danger, or release would defeat the ends of justice. Then the bail may be denied, and board must record reason for denying the bail and circumstances that lead to the decision. And when the child is in conflict with law, is unable to fulfill the conditions of bail order within 7 days of bail order, such child be produced before the board for modification of the conditional bail. So this is also there. Then duty to produce the police immediately after apprehension. Now here you will see that there should not be any delay. So within 24 hours, the police is under duty to place the child before the board, and the child, if the board is not sitting, then presence of two members is required, including principal magistrate, for making the order under Section 18(3). And in case of difference of opinion, the majority opinion will be prevailing. And if the child is in need of care and protection, then the police shall produce the child before the child welfare committee under Section 7. Now, who is a child in need of care and protection is under 214. A child who is a imminent risk of marriage before attaining the age of marriage, that is completing 18 years in case of girl and 21 years in case of boys. Homeless, abandoned, street children, forced labor, beggar, abused, tortured, neglected, exploited, mentally or physically challenged, mentally or physically ill, having incapacitated parents or no parents, a missing or runaway child whose parents are not traceable, abused, tortured, or exploited for purpose of sexual abuse or illegal act, vulnerable, as in is likely to be introduced into drugs or drug abuse or trafficking, abused for unconstitutional gains or consensual gains, or victim of natural or man-made calamity. So this is there. Who these are the children who are in child in need of care and protection, and they can be produced before the Child Welfare Committee. And so what any police officer who is a special juvenile police unit officer can or a district child police protection officer or inspector appointed under the labor law, any public servant, childline service or voluntary or non-governmental organization, child welfare officer or probation officer, or any social worker or public spirited citizen by the child himself, any nurse, doctor, management of nursing home, hospital, or maternity leave can actually produce the child before the committee. Now, order that can be passed by the committee in respect of CNCP after inquiry under is given under section 37. So, declaration that child is in need of care and protection, restoration of child to parents and guardians and family, placement of child in children home or fit place or specialized adoption agency or for adoption, then placement of child with fit person, foster care orders under 44 and sponsorship order under 45, and declaration that the child is legally free for adoption is given under section 38. Now, final order that the juvenile board for the child in need of conflict in conflict with law against a child in a conflict law can be passed. This is a revisiting. I told you I have discussed there also. Just coming back to it, that is allow the child to go home after advice or admonition and counseling to the parents and guardians of the child. Second is direct the child to group counseling. Third is order the child to perform community servicing. Fourth is order the child to or parents or guardians to pay fine. Fifth is to order the release on probation of good conduct and place him under the parents care of the parents, guardian or fit person by executing a bond. Sending the child to a special home for maximum period of 3 years. In addition to such order, the board may pass order to send the child to attend school, attend vocational training, attend therapeutic center, addiction program. And so when the board, after preliminary assessment under section 15, passes an order, then there is a need for trial and the said child as an adult, then the board may pass an order to transfer the case to the children court. Now, board may order police for registration of FIR for offense committed against child or against a child who is a child in need of care and protection. So the very famous case of Chandigarh home rape case, where a specially abled victim was raped by the caregivers in the home. Uh, they can be accused of under this law as well as the offense committed by them, because in that case it was rape. So, duty of the police officer to inform parents under section 13, mandatory, that when the child is in conflict with law, apprehended by police, shall inform parents or guardian of such child if they are found to be directed them to present at the board before the child is produced, and probation officer, if no probation officer is available, then child welfare officer for preparation and submission of social investigation report. Now, when the child is in conflict with law, attend 21 years. So, 3 years till 21, he can be there in the special home. But after 21, when he completes 21 years of age, uh, yet to complete prescribed term of stay. That means his punishment is 5 years. He has already completed 3 years, but another 2 years he has to complete, and he has attained 21 years. Then in that case, the follow up by evaluation of probation officer on the district child protection unit or social worker or by children court to know whether child has undergone reformative changes. After the completion of evaluation procedure, child court decide to release the child on such condition it may deem fit, which includes appointment of monitoring authority, which is the remainder of the prescribed term of stay, and decide the child has completed remainder of the time in the correctional home. So this is also possible that the child may be sent to the correctional home. Now, if a child is runaway child in a child in conflict with case, means he has jumped bail or he did not return, then the runaway child within 24 hours after apprehended may be brought before the board, and which passed an original order in respect of the child, or to the nearest board where the child is found. So no additional proceedings can be instituted in respect of that child. So no further punishment can be enhanced, but then the normal procedure will go. So provision regarding abandoned, missing and surrendered children, as I told you that if parents are not able to take care of the child, can surrender child. So any individual or organization or police officer finds an abandoned child or missing child or orphan child without family support within 24 hours, give information to the Childline Service, nearest police station, Child Welfare Committee or District Child Protection Unit, hand over the child to the child care institution registered under the law. So, if no information given within 24 hours, then it would constitute an offense, and such offense shall be punishable with imprisonment for up to 6 months or fine of 10,000 rupees. So, even special juvenile police officer or juvenile welfare police officer can also be punished with such offense for such offense. And if parents or guardian wishes to surrender children, shall produce it before the committee, or committee on satisfaction will cause a deed to be executed by the parents or guardian, and parents and guardians shall given 2 months time to reconsider the decision. And in intervention period, the child may be placed with parents or guardian or specialized adoption agency, or in a children home meant for children above 6 years of age. So there are certain special provisions under the institutionalization and alternate system, that board on satisfaction is about empowered to dispense with the attendance of the child for purpose of inquiry. Where attendance of the child is required for board or committee, such child can be entitled to reimbursement his escort traveling expense and board by the board and committee, or child district child protection unit, as the case may be. And where the child who has been brought before the board or committee requires prolonged medical treatment, the committee or board shall send the child a place for medical treatment. And where the child is found to be mentally ill or addicted with alcohol or drugs, then committee or board may order removal of such child to the psychiatric hospital or psychiatric nursing home according to the Mental Health Act and rehabilitation centers. So, child law frames for child protection, only just give you a cursory glance of it. Prohibition of Child Marriage Act, Commission for Protection of Child Rights Act, Juvenile Justice Care and Protection Act, Persons with Disability, Equal Opportunity Protection Rights of Full Participation, Preconception and Prenatal Diagnostic Technique, Prohibition of Sex Selection Act, Infant mild substitute feeding bottles and infant Food Regulation Production and Supply and Distribution Act, Immoral Trafficking Prevention Act, Child Labor Prohibition Act, and we also need to keep in mind the Guardians and Wards Act and Young Persons Harmful Publication Act while we are dealing with the problem of child protection. So protection is there in the law itself. Handling by special juvenile police, section 10. Handcuffing of juvenile prohibited under by the judgment in 1995. Police should not be in uniform, and all procedures should be child friendly, section 7. Child and juvenile cannot be kept in correctional home or lockups under section 10. No death penalty, life in prison without possibility of release can be given as an order. Proceedings are informal, participatory, and private. Parents are to involve no juvenile processes, right to free legal aid, no joint trial of juvenile with an adult. Information about juvenile cannot be released to media. Inquiry under section shall be completed within 4 months, and preliminary assessment under section 15 shall have to be completed within 3 months from the date of such first production. Now, if inquiry by the board or petty offences remain inconclusive after 6 months, the proceeding shall be terminated under section 14(4). And facility for interpreter or translator, where the child fails to understand the language used in the proceeding, or when child is a specially able child, then special educator and interpreter is required. So by this I end my discussion. I'm thankful to you all for giving me this opportunity, and now I'm open for questions. I can take up some questions.
Yes, ma'am. Thank you, ma'am, for the delightful and insightful discussion over the juvenile justice system, institutionalization, and alternatives. Ma'am, there are questions which have come from the participants. I would be narrating the questions. Kindly answer them. The first question is that one of the very basic questions: what are the fundamental rights of the juvenile offender protected under the Indian laws?
For fundamental, what I will say, that the first requirement is when a child in conflict with law is apprehended. From that point of time, the child friendly approach has to be there. Child friendly approach means there are lot of do's and don'ts. Like for example, if the child in conflict with law is been apprehended, then the special juvenile police unit should not be in a uniform, because child always fear. The child must have done the crime in the heat of the moment. So when the child has committed the crime in the heat of the moment, he must be given, he has to, ability to explain and inform the details. So maybe he must be used by some adult for commission of that crime. In that case, he would fear to disclose everything to a, person in uniform. So, and the person who is in uniform also needs to know that how he should behave with a child, and the person has to be trained in the child psychology so that he understands the psychology of the child. So starting from that time onwards, human rights of the child needs to be protected, and all the principles which I have discussed in the first part of my discussion needs to be taken care of by the criminal justice administration when they are dealing with these kind of child. Now, when we are talking about child in conflict with law, sorry, child in need of care and protection, there what happens? Sometimes what happened? The special juvenile, this trafficking police unit, they rescue the child from the say brothel or a place where the child was being trafficked. So at that point of time, if the child is a girl child, then what behavior should be done? The team should have a women police officer in that unit, so that these girls can be handled by the women. So these are some basic rights without which, even in a child in conflict with law, they have certain basic rights needs to be protected. And the goal and objective is giving them their, ensuring their rights. They should not be harmed in the process of the criminal justice administration. So re-victimization should not be there.
Right now. Ma'am, the next question is what role do NGOs play in the Indian juvenile justice system?
Without the NGOs, the system would not work at all, because their role has become very, very important under the Juvenile Justice Care and Protection Act 2000 old law, and even 2015 law, because in all the cases, uh, maximum homes are run by non-governmental organization, and these homes provide the basic care to these child in conflict with law or child in need of care and protection. So uh, their role is again very important, and for them also they need to take a child friendly approach, and they also have certain do's and don'ts, because we have found that Muzaffarpur Nari Niketan case, or all those cases which are there against these homes and women home or children home, what we find is that they are the ones in custody of the children, and they abuse their power. So in that case, dealing with them with hard hand, and training them with child psychology, child friendly approach are need of the. Without NGOs, it will not be possible.
Yes, ma'am. Ma'am, one of our participants, Kailash Shafale, supposedly I have taken the right name. He has put on a question that if child in conflict with law has committed very serious and heinous crime, is he tried in a regular court for more severe punishment as the victim will not receive justice?
See, here the procedure in the law is that he will be, first of all, his mental capability will be assessed, that he has the capability to commit the crime or not. After that preliminary inquiry, if it is found that he was mentally mature enough to commit the crime like an adult, then his case will be transferred to the children court. Now, children court have been designated as the courts are sessions court are designated as children court. But as I have told you, they cannot be tried along with the adult, because the children court should also adopt child friendly approach. And there, the court may give higher punishment, but life imprisonment and death penalty cannot be given, or life imprisonment without chances of remission cannot be given. That is already there in the law. So punishment can be given, stringent punishment, but not life imprisonment without remission or death penalty.
Okay, ma'am. I suppose this question is related to my earlier question of the NGO. How far the Central Adoption Resource Authority has been helpful in meeting out the objectives of the Juvenile Justice Act?
See, they were the ones who came up with the guidelines, and then the institutional adoptions agencies, the registered adoption agencies, were required to follow those guidelines. Now, those guidelines have been incorporated in the law itself, in the sections, provisions of the law. So, what happens? The guidelines have now become the law, and those have become very mandatory. One problem which I found, that the new amendment which came in 2019 has created, that the people who are like DM has been made the nodal agency for the given in adoption. Now, then in that case, what happens? They are the adjudicating authority, and they are only the ones who are actually giving an adoption. So there is a conflict of interest. So I am waiting for someone to file a PIL on this to challenge it, because a lot of child trafficking were taking place through the adoption, and this has actually opened a floodgate whereby the power of the court has been taken away and given to the district magistrates. So there I find,
Might be because of the technical glitch.
you can hear me.
Mm, mm.
I hope I have answered the question.
Yes, ma'am. There was a technical glitch. The video
I
was
will
not
repeat.
being uploaded. Uh, no, ma'am, it's okay. Hopefully, they have got the answer. One and the last question, ma'am, with regard to your entire experience over the field and how far you have trained so many officers, but related to this particular field, I just wanted to have a knowledge over the fact that how far this determination of the juvenile delinquency factors have played an effective role in the administration of criminal justice.
What I would say, the approach of the court, the approach of the police, we have not overcome the colonial mindset. Though, we have actually got the law changed, and we keep on hitting hard on that, implementing the new changes, but the mindset has not changed. So, for example, the police will carry the criminals and the juvenile in conflict with law together in one vehicle. It is next, it is serious human rights violation, because if there is paucity of vehicle, then in that case, for that matter, you can take the public transport for the child, or have an alternate method, not taking the criminals along with the juvenile in conflict with law to the court or board, because if board and court are nearby, they would take the same vehicle. Or say what happens, the pant would be the uniform, and the shirt he has changed, but he is having his weapon and everything with him. So then that does not make any change. So a lot of trainings are being done, they are made aware, but they also show their problems, that what problems they are facing. And the budgetary allocation is so low for the police,
Right.
or even the prosecution and the judiciary. So in that case, it is next to impossible. We have the law in place, but how much allocation of funds are there for the smooth functioning of this system? And if I talk about the institution, the NGOs, 6 month delay in making payment to them. How do they run? 6 month deficit
Right.
means huge, and their salaries are sometimes delayed by 6 months. The caregiver's salary, interpreter, educators, no payment provisions. Why will an interpreter and educator come? So these are huge problems I have also faced while training them. They tell about these, and system is running.
Right, sir. Right, ma'am. Obviously, the black and white letter of law and their very implementation has a very wide difference in the very effective implement. Or what would we say? The effective and the most impactful implementation. It would be there only when we are following the letter of law to its very spirit, which amounts to almost practical difficulties. Because of the practical difficulties, that cannot be implemented as such also. Ma'am, I'm really thankful for your insightful lecture, and hopefully we would be having your association in the future as well with the Faculty
Thank
of
you
Law,
so much.
Integral University. Thank you, ma'am. Thank you, ma'am.
Now I leave.
Yes, ma'am.